Yes.
Yes, Mr. Pasha.
My Lord, I appear in item 501.3, which is Spandan Biswal versus Union of India. Lordship, the petitioner is a practicing advocate of my Lord's court and a specialist in financial regulation. And so it's in the perspective of placing this law into the context of financial regulation that I stand before my Lords. My Lords, just before I begin with that, I just want to round off the argument that was being made by my learned friend, Mr. Farasat, for which, my Lord, I refer to clause 11 of the electoral bond scheme, which is the payment options. And I'll read it out, my Lord, need not bother. It says, all payment for the issuance of bonds shall be accepted in Indian rupees through demand draft or check or through electronic clearing system or direct debit in the buyer's account. Lordship, so cash is noticeably absent from the forms of consideration which are permitted for purchasing an electoral bond. And therefore, the question of any black money coming into the system has been cut out at the inception itself, at the stage of purchase itself, is excluded. Lordship, and I contrast this with the bearer bond scheme, which was under consideration of my lords in R.K. Garg's case, where, Lordship, the specific and stated objective of the government was to bring black money into the white system, and therefore purchase of those bearer bonds through cash was permitted, and that scheme was eventually upheld on the basis that all other, it's just providing another instrument, because all other laws, etc., will continue to apply, and wherever there is a financial irregularity found in terms of income tax, etc., the person will be liable. But just the cash which existed in the economy, which existed outside the white economy, comes into the white economy, which is the one thing which is excluded in this case. Lordship, so the one ground on which a similar scheme of bearer bonds, not in the context of elections, was upheld by my lords in R.K. Garg, is the one ground which is not available here. Lordship, now my primary argument is that this the electoral bond scheme is manifestly arbitrary. And for that, Lordship, I will just read out the relevant few lines of my Lord's judgment in which the concept of manifest arbitrariness is defined. And Lordship, just by way of an aside, I wish to point out that it is commonly believed that the doctrine of manifest arbitrariness and the striking down of legislation on the grounds of manifest arbitrariness came into our system and became the law through Justice Nariman's opinion in Shaira Banu. Lordship, I feel that that is actually not correct, because Justice Nariman was in a minority in terms of the doctrine when he expounded the doctrine. Justice Keha's opinion said that personal law is not statutory, and therefore the question of striking down a statute did not arise under Article 14. Justice Kurian Joseph, while he is with Justice Nariman on the operative directive, disagrees with him on the fact that it is statutory. And so, in that sense, his one line saying that I agree with my brother's opinion on the doctrine of manifest arbitrariness is completely obiter for Justice Kurian, because he is saying that this is not statutory and therefore not subject to Part 3. So, in that sense, that opinion is an opinion of 2 judges, but it was in Puttaswamy 5 judges, where Justice Sikri, speaking for the majority, applied and adopted that doctrine of Justice Nariman, that I feel that it for the first time became law. But now that it is, Lordship, I'm just reading from para 95 of the opinion of Justice Nariman as adopted by Justice Sikri.
So how do you formulate that it is? Just give us how, according to you, it is manifestly arbitrary.
Lordship, that
you have the doctrine of manifest arbitrariness you have referred to in your written submission.
Lordship, please.
That we look at. If you can formulate how it is manifestly arbitrary.
Lordship, please. So I'm just, what are the elements of manifest arbitrariness is important for that. And a constitutional infirmity is found in Article 14 itself. Whenever legislation is manifestly arbitrary, that is, when it is not fair, not reasonable, discriminatory, not transparent.
So in our case, how is it manifestly arbitrary?
Lordship, not transparent, so ipso facto. Not transparent, capricious, biased, with favoritism or nepotism, and not in pursuit of promotion of healthy competition and equitable treatment. Positively speaking, it should conform to norms which are rational, informed with reason, and guided by public interest.
So according to absence of transparency.
Absence of transparency and Lordship, public interest. And for that, Lordship, I am just juxtaposing the legislative policy behind these amendments and the electoral bond scheme with the legislative policy that exists in the context of other financial regulation. Lordship, in the electoral bond scheme, in rule number 3 or clause number 3, which is eligibility to purchase and encashment of electoral bonds. I'm reading it out. The bond under this scheme may be purchased by a person who is a citizen of India or incorporated or established in India. So, Lordship, the only test for a company is that it should be incorporated or established in India. In all other financial regulations, Lordship, I will point out that there is a concept of beneficial ownership where if beyond a certain percentage, there is foreign ownership in that entity, it is treated like a foreign source. But here, to purchase an electoral bond, as long as the company is incorporated in India, it is an eligible purchaser. And Lordship, what this results in is the absurdity that while we do not permit investment by an entity which has 51% foreign shareholding, we don't permit that entity to invest in a company which, say, deals in the media, because we don't want foreign control of our media. But we have no problem in allowing such a company to purchase bonds and transfer to political party, and therefore, in that sense, invest in a entity that runs the country. So, that's the absurdity that I wish to point out, Lordship, that in all financial regulation, the idea of control and beneficial ownership of foreign corporations and a different standard being applied to them is the norm. And it was the norm here as well, because under FCRA, before the amendment, an entity which had more than 51% foreign shareholding was treated like a foreign source. But this amendment now does away with that and treats all entities, as long as they are regulated in India, at par. And I wish to point out, Lordship, some of the differences that exist between this scheme and the scheme of any other method of funding coming into India. Lordship, foreign investment in India is governed by the Foreign Investment Management Non-Debt Instruments Regulations 2019. Lordship, which are at page 9047.
Your Lordships made it clear in the morning. This issue is DTECT.
This is not FCRA. I think it's under the impression that I'm dealing with FCRA. I'm talking about foreign exchange management. So I'm just placing this electoral bond scheme in the context of foreign.
They are twin arguments.
That's not a twin. That's a FCRA is a separate argument there, which is I'm talking about foreign exchange management, Lordship. So because in this context, when in Rule 3 it says that any entity incorporated in India may purchase electoral bonds. So by definition, a company with foreign investment is being allowed to purchase electoral bonds. And so, Lordship, I just wish to point out that
already argued that any entity in India which is merely registered in India, even if it doesn't carry any activities here, doesn't earn any profit, still a company is situated in abroad can use this company as a shell company and permit it to be transferred.
I'm going to pitch it a step higher, Lordship. I will point out that the government and the legislative policy does not permit a company from incorporated in certain jurisdictions to even enter into procurement contracts with the government. But for purposes of funding political parties and thereby having a say in the electoral politics of this country, there is no problem by virtue of this amendment. So just the comparison, Lordship, points out the legislative absurdity of having a clause here which places all Indian corporate entities on a similar footing. Lordship, I was looking at I was pointing my lords out to the regulation at page 9047 of my of volume 4. Lordship, and I am reading Rule 23. Indian entity which has received indirect foreign investment shall comply with the entry route, sectoral caps, pricing guidelines, and other attendant conditions as applicable to foreign investment. Which means that a company which has downstream foreign investment, which has foreign investment in terms of its downstream investments, it is treated like still a company which is a foreign investor for purposes of foreign exchange management. So, Lordship, and hence the absurdity that there are certain sectors, for instance, which are prohibited for foreign investment, like atomic energy or defense or space. There are certain sectors which are restricted to foreign investment, like, for instance, media, where more than 49% ownership is not permitted. So this company can't invest in all of those sectors and in companies engaged in those businesses, but is allowed to invest in, or rather allowed to transfer its funds to a political party and therefore become a stakeholder and participant in the electoral democracy of this country. Lordship, I won't take my lords to those pages, but I'll just point out, my lords, to the master directions which are issued under this scheme at page 8850. Lordships will note at page 8877, first at page 8875, downstream investment. And the way it's worded is very relevant. The underlying principle of downstream investment guidelines is that what cannot be done directly cannot be done indirectly. So therefore, Lordship, foreign entities are not being permitted to purchase electoral bonds. But an Indian entity with foreign investment, even if it's 100%, is permitted to purchase electoral bonds, which is prohibited in the context of business, but is permitted in the context of political parties. Accordingly, downstream investments, which are treated as indirect foreign investments, are subject to the entry routes, sectoral caps, or investment limits, as the case may be, and pricing guidelines and attendant conditionalities for such investment as laid down in the non-debt instrument rules, which I read out. And ownership of an Indian company is the beneficial ownership of more than 50% of the equity instruments of such a company under this FDI policy. Lordship may now take page 8900 of volume 4.
What is the submission now?
Lordship, this is press note 3 of 2020, by which it has been stipulated that any country which shares a land border with India, investment from such a country is treated on a different footing from investment from any other country. And whereas investments, say, in the manufacturing sector may be 100% automatic, but if it is from a country that shares a land border with India, that is solely under the approval route, which means that it will not be automatic. It will require an application to be made for approval to the government of India. Therefore, Lordship, what submission that I'm trying to make is that an investment from China into a manufacturing entity is not treated as par as investment from anywhere else. But if the same country then permits purchase electoral bonds, then that is permissible. Again, so this land border sharing distinction that exists for business doesn't exist for...
Yeah, because that is taking into consideration the interest of security of the state.
Lordship, exactly. So therefore, if security of the state is impacted, if a company merely invests in the manufacturing sector in India, is it not impacted if Chinese investment is coming into a political party? Lordship, so much is being made today.
It is coming. It has stopped now because of this.
Lordship, so we are currently having this issue which is in the press of a news organization having received some fund from China. So Lordship, so by this standard, a country like China cannot invest into businesses in India except through a separate approval route where it is monitored and scrutinized. But a Chinese company can fund a political party and theoretically funnel millions of dollars into politics in India on a presumably, like my friends have already argued, a principle of quid pro quo. So, Lordship, this, in fact, that difference in legislative policy for funds coming into India in any other context versus in the context of political parties manifestly arbitrary is my submission. Lordship, one or two more instruments I'll just point out to my lords. My lord may see page 8827.
Matters of policy, really. Whether you are saying that a company in China, because China shares a land border, they cannot bid for a contract. But your case is here that they may have invested in electoral bonds.
So therefore, we feel that there is a security threat if they bid for a contract in India, but we feel no security threat.
They are in the realm of policy, That's
But in fact, that is why policy is subject to the doctrine of manifest arbitrariness if it is so absurd, where it is contrary to public interest and where it is non-transparent.
Thank you. We'll now tomorrow, at the most, Mr. Hansaria, 15 minutes for you and 15 minutes for Mr. Hegde now.
It's for me. It's just 10 minutes. I represent a regional party. We had made an application, written submissions for that. I won't take more than 10 minutes.
We'll have a look at the written submissions of Mr. Hansaria, Mr. Hegde. And
To be on realistic side, not 15 minutes. I was requesting your lordship an hour. I'll try to have it in 45 minutes. I have to take your lordship the journey from 1958, my lord, how it developed, not since 2013. There is a long journey, my lord. The parliament has accepted the recommendations made by Justice Chagla, and I'll show to your lordship, lord. I'll try to be as brief as possible.
Who are you appearing for, Mr.
I am for an entrepreneur, my lord. We have, I filed my written submissions, which are before your lordship.
I also make submissions.
I have not.
And based on that, we'll decide in the morning how much time.
As possible.
Shall I also make a very short submission?
I will try to be as brief as my lord.
Shall I make a very short submission, my lord, before your lordship parts with, my lord? But I just wanted, I was listening to the entire deliberations, but I wanted to make a very short supplementary submission. But we only with respect to the question of political liberties.
Submissions, all three of you, and then we can see how much.
Please, your lordship.
So we begin with the clean slate.
Your lordship will see that, and then whatever your lordship says, we'll go by that.
Shall I make one request, my lord? Shall I make one request before your lordship leaves, my lord? But I will just make a very short submission supplementing, my lord, and emphasizing on a point which has not been addressed at all. That is to say, on political equality and the basic feature in the Indian constitutional context. My lord, distinguishing.
Filed your submissions, Mr. Raj, no?
Yes, I wanted to make a submission, but distinguishing.
Have you filed your submissions? Have you filed your written submissions?
I can do it today if your lordship permit, because I was prevented.
Now
with
it's
the
too
hearing.
late.
I can do it today if your lordship.
We can't take the attorney and the solicitor by surprise.
Lord, I will just rely on my immediate.
Please, your lordship.